My name is Richard L. Koenig. I came to Oregon in March of 1985 to fight in the courts for my son, who was kidnapped by folks, including the courts. I came up here having been arrested in my home state of California, where my son and I lived together, because his mother, her boyfriend, were pretty in tight with the local authorities in Washington County, Oregon. I began an incredible education in corruption. Her associate, my son's mother's boyfriend, was a former CIA operative during the Vietnam War who apparently had been employed to help the flow of drugs and distribution into America. And apparently that's a career path that once one undertakes it, one does not get off. And I began from that point to learn about his contacts with state government, and from his contacts in state government I began to learn that there probably isn't any state government. It's more like a facade. It is something operating under the color of law. It's a pretense. It's a business. It's a business that follows the corporate agenda. The corporate agenda is the bottom line at any cost. And I have been confronting that agenda in a lot of different ways. For many years I lobbied from year to year to year as a family law reform advocate. I do have the Friendly Parent Bill. I have the credit of getting the Friendly Parent Bill on the books in Oregon. Custody shall be presumed preferable to the parent most likely to facilitate a relationship with the other parent, between the child and the other parent. On one occasion when I was lobbying against the Department of Justice's proposal to take professional driver license or professional licenses away from deadbeat parents, the spokesperson, and I'll give you his name, he's no longer in Oregon, but maybe you'll meet him in Florida, John Ellis, was speaking to the Senate Committee on Business, Law, and Government, and he said, "This year you folks must pass a law that provides equal protection to the ex-spouses of doctors, architects, landscapers, and other professionals, because the year before, the session before, you passed a law that allowed us to do that to drivers, to take driver licenses away when they're in arrears." And my little wheels are turning, and I'm going, huh? Equal protection to taking professional licenses means that taking driver licenses are taking professional licenses. And it took me about 5 seconds to process equal protection, but I could not believe it. I've grown up all my life to think that what I do when I'm behind the wheel of my automobile is some kind of privilege that I have to pay for. So I started asking questions, and I'd been there around the State House for years, and I started with Legislative Counsel. Well, actually, first I started with the library. And I went to the library, and I had this experience with a book. A book reached out from the shelf and touched me on the leg. I picked it up, and my thumb went in between the pages of, it was the laws of 1921, and I went in at chapter 10, and it said, "We, the legislature, intend to regulate every vehicle that transports persons or property for compensation or hire, and charge them enough money to do the damage, to fix the damage they do to the highways with their big rigs." They didn't say big rigs, but with their commercial trucks. And then I called Legislative Counsel, and I said, "Greg, guess what I just found in the library? This." I said, "Surely there must be something that is in between then and now. Isn't there What is that? Where was the transition to most people? And he goes, well, the last substantive change was 1925. So I went back to the library, moved over a few sessions there every other year, so it was only a few books, and I looked at the 1925 general laws, but it was exactly the same relating clause. It said, we, the legislature, intend to regulate every vehicle that transports persons or property for compensation or hire and charge them enough money to fix the damage they do to the highways. Whoa. The substantive change was that they divided motor vehicles, the regulated thing, motor vehicles, into 6 different classes that year. Was that a substantive change? Well, that's what Greg Chamoff, legislative counsel, the attorney for the state legislature, told me. That happens to be 1925, Chapter 380, by the way, for the researchers among us. And that changed my life. I said, the people who've been beat up in family court are pathetic. They are emotionally disabled. They are financially bankrupt. They're worthless as troops. They cannot fight. They typically lose their ability to fight. And maybe in America, with the Americans' love affair with the car and all the highways that we have, the public right-of-way, by the way, maybe this is what it will take to organize active resistance to what by then I already come to understand was the corporate agenda. Even the family law thing, you divide up a family, then you have a requirement of 2 refrigerators and 2 washers and dryers and 2 cars and etc. It's good for business. It's the corporate agenda at work. But I've been opposed to it now for some years. So I thought, this may be the way. And when I looked up started doing a little bit more research, becoming a little bit more aware, just getting my toe in the water, I started realizing, wow, this is really easy. Highway means, and there's a definition that says highway means every public way, road, street, thoroughfare, and place, including bridges, viaducts, and other structures within the boundaries of the state, open, used, or intended for use by the general public for vehicles or vehicular traffic as a matter of right, not privilege, distinct from privilege. I said, how can I miss? It's just the words on paper. What's there to convince anybody of? It's fraud. We have all been defrauded all of our lives. Our parents and their grandparents have been defrauded into thinking that our right to travel, our right to use the public right-of-way is something that we have to pay for, that we are regulated in our use of, that we are cited for violation of what, rules, even if we don't hurt anyone, even if we cause no distress or anything? You know, there's no probable cause to believe we've committed a crime and therefore be deprived of our life, liberty, or our money? How can that be? It's so simple. It is so obviously wrong. How can I lose? I'm going to do this. This is the path that I'm going to go down. I'm going to become it was a conscious decision. It was not hard to make. I am going to become a traveling advocate. So I began to do the research. I began to interview the people who put the conspiracy together, who put the conspiracy on the books. I lived my life in state archives. I lived my life on the bookshelves of the public libraries, in the Supreme Court. The next biggest library in Oregon is the Boley Law Library at Lewis and Clark Northwest School of Law. One of my most facilitated search venues is the Multnomah County Law Library, where we have a wonderful librarian who's been a part of every legal maneuver that I have made over the last 28 years now. She's a saint. She is essential to my life. I fear for her well-being if I say her name, but I do have friends. It got to the point where it was almost expected. I would get to the hard part of the interviews with my conspirators. The people who put this together are conspirators. And they would dependably break down. They could not answer the questions. And I'll give you, for example, we have people who help write the laws. They're called legislative counsel. The Office of Legislative Counsel is a stable of attorneys, maybe 12, 15 attorneys that write law for different areas, in different areas. The attorney who wrote transportation law in the 1980s was named Brad Swank with a double D. He was responsible for drafting, redrafting the entire motor vehicle laws of Oregon and updating them during a 3 legislative session process in the early 80s, from 81, 83, and 85. During those 3 sessions, I interviewed him. And before I interviewed him, I read his book on how and why I wrote the vehicle code the way I did. And it's called, for the researchers among us, it is called Introduction to the Vehicle Code 1986-87. And I said, Brad, I know that part of your intention when you wrote this book was to avoid redundancy and to make things easier to understand and use and amend. I said, now, in your section here on types of driver licenses, classes of driver licenses, it looks like you didn't follow your format, your own format. You've got your Class A commercial, and your Class B commercial, and your Class C commercial. But then you start over and you say you've got another Class C license, and then there's another Class C license. So you got 3 classes of C, which doesn't really make sense unless you take the endorsements off. But by putting the endorsements on it, you've created redundancy, because the next section of law below licenses is endorsements. You've got the same discussion going on twice. The redundancy that you were going to eliminate is inserted. Why did you do that? And that's where the conversation broke down. And I spent some hours with this gentleman comprehending how premeditated and wicked the whole thing had been. I talked to the senator who was in charge of the Joint Committee on the revision of the Vehicle Code, who worked closely with Brad Swank, needless to say. And she was a neighbor of mine in northeast Portland. And I asked her why she had done some of the things she did. And I had coffee with her, and I got to one point where I said, you know, there's a Senate bill, Senate Bill 124 of 1985, that you passed at the behest of the director of DMV, David P. Mumau at the time. And Mr. Mumau had come to you folks and specifically admitted that historic, and these are the words that Mr. Mumau used, historically, my agency has sold a lot of title and registration, documents of title and registration, without authority in current law. And then he asked you folks to allow him to continue this practice by passing a law to let him. And this law was to become implemented by the adoption of agency rules. And she said, oh, I think I've got to go home. I just remembered the grandchildren are coming over today and I have to clean house. And of course you don't clean house when the grandkids are coming over, because the grandkids mess the house up. But that's how wicked, and her name is Jane Cease, former Senator Jane Cease. Her husband was a senator before him, before her. Anyway, it just so happens that every bill for raising revenue, just like in the federal Constitution, all the state constitutions have to have some kind of continuity, similarity. Every bill for raising revenue must originate in the House. And this was a Senate bill to preserve an unlawful revenue stream that he admitted was unlawful, had never been legal. And these are the kinds of interviews that I was having. Turns out one of my confidants, a gentleman that I had carried on with for years as a family law advocate, who had become the court administrator here in the largest county in Oregon, Multnomah County. We were on a first name basis for decades. His name is Douglas M. Bray. I knew him as Doug. How you doing, Doug? Turns out that Douglas M. Bray ended up being the most recent and longest on the job as the administrative secretary, executive secretary of something called the Minor Court Rules Committee. The Minor Court Rules Committee was instituted in 1959 to, as I call it, and it's not exactly like this in the books, but I say to make the public feel welcome in traffic court. Doug Bray and I had talked about family law, and when I realized that the enforcement of motor vehicle laws was kind of shaky, I started talking to him about that. And he was anxious to hear what I was finding out. And it turns out that he was doing intel gathering to see how much I knew and how far I was getting in my research. But he had been the executive secretary for this Minor Court Rules Committee for 11 years before he became the court administrator in Multnomah County. And he never told me, never breathed a word about that. It took me, I don't know, probably wasn't until 6 or 7 years ago that I finally found out who he was. I stumbled across his picture with the group, the Minor Court Rules Committee, in one of those dusty old books in state archives. Wow. And so these are the kind of people that I rub shoulders with, that I know better than my friends. Frankly, I have associates, I have relations with people that have something in common, I have allies, but in Oregon I have never developed a social network. I have nothing that you would call friends. I left home to fight in Oregon, and I know my enemies in Oregon better than I know anyone else. These are some of them. Let me give you a couple of quotes. We had a gentleman named Dave Frohnmeyer. We still have him around. He's still kicking. He's currently the director of the State Sunshine Committee, our transparency in government guy. Okay, recently retired from the University of Oregon as the dean. He was our Attorney General in the 80s when I first came. He helped revise the vehicle code in 1985 during the concluding year, the final session of the revision of the vehicle code. He came to the Legislative Assembly to Jane Cease's committee, and with Senate Bill 118 for the researchers among us, and he said, "I'd like to change the definition of driver license to, quote, mean the same as license," close quote. That was the bill language. Today we have that language pretty much verbatim under the current ORS, ORS 801.245, the definition of driver license. And it says the term driver license is interchangeable with the term license. So what do we have when we turn to the term license in law, in Oregon's revised statutes? Well, it's certificates, registrations, or other similar forms of permission required by law to pursue any commercial activity, trade, occupation, or profession. And that's under ORS 183.310, subsection 5. The Administrative Procedures Act, which is adopted throughout the states, it's kind of a uniform protocol for agencies, state agencies, to abide by, especially in the incorporated United States and the subsidiary incorporated entities of the United States, like the state of Oregon. Okay? So this is a uniform law. Some states have added to it. We have cut out a few things, but every state has some version of the Administrative Procedures Act and some similar form of the definition of license. Permission required by law to pursue any commercial activity, trade, occupation, or profession. Okay? This is how easy it is for us to understand if we only take the time to pick up the books and look at the words that are there. I put a lot of stock in words. My mother was a school teacher, and she had an ambition to have a lot of family, a lot of children. She wanted to have a dozen, and I was her first, and she knew that I wouldn't get a lot of her attention, so she gave me words. She gave me phonetic reading and a library card, and I was pretty much on my own with books from age 4 or 5 years old. I was reading by the time I was 4, and in the library a lot, well before I was too young to go to first grade, and I was the only kid to carry books to school to read because there wasn't anything really worth reading in school, thanks to my mom. Some of my early childhood influences, friends, literary heroes included, well, Ben Franklin was one, and Poor Richard's Almanac. I kind of identified with that guy who was, when he was writing Poor Richard's Almanac, he was only 14, so maybe that was, an age affinity thing. Thomas Jefferson. Thomas Paine was a big guy with me. But because of these authors, these people who were into words, the use of words, and the revolutionary use of words, that colored my perceptions of what is to this very day, as a matter of fact. And I have a hard time turning loose of the concepts that were instilled by these folks at a very early age. And I'm still doing it. As a result of doing what I do, I have engendered a lot of hostile feelings among my corporate neighbors and their purchased minions in the Legislative Assembly. I now have been prosecuted for calling government offices to petition for redress. Not only prosecuted, but successfully prosecuted. I'm the first person, I set a precedent in Oregon for calling the sheriff's office in Washington County and being convicted and that has gone up to the Supreme Court. The Supreme Court did not address it on a constitutional basis, but nevertheless the decision stands in State versus Koenig that somebody can be convicted of calling the sheriff's office. It's called telephonic harassment. If you look up the crime in Oregon, telephonic harassment, and I'll give you that statutory citation, it's 166.090. And then you go to the annotated statutes, you'll find me as the only case that is there for having called a government office, the Washington County Sheriff's Office. I'm currently facing my second prosecution for calling the Clackamas County Sheriff's Office. And the district attorney over there, I'm going, excuse me, his name is Brian Cinsoni. Excuse me, Brian, but whatever happened to that right to petition government for redress? And he says, well, I read the case law on this, and you know darn well that the Supreme Court has said you in particular can be convicted of calling the sheriff's office, and I'm going with that. And so here I am, facing my second prosecution for calling the Clackamas County Sheriff's Office, attempting to seek redress. And I might add, we do have laws here that say that the district attorney's office, actually it says the Department of Justice or any district attorney's office is the investigative agency for purposes of racketeering. That's ORS 166.715 subsection 3. So I was hitting on the district attorney's office in Clackamas County, and they said, call the sheriff. We don't do investigations. And I go, what? You don't go with the legislative assembly's will? You're in violation of what? Public law? And they said, just call over there. Don't bother us. And so, having been referred to the sheriff's office, not just once, not twice, but a number of times, the sheriff finally gets tired of shoving me back to the district attorney's office. It's like a tennis ball type of thing. And so finally they institute charges against me for having called them once too often. So I have kind of a bone to pick with the judicial system and the legislative assembly for their, not the legislative assembly specifically. It's more like, and let me give you another example here. Let me give you the significance of Mr. Mumau's Senate bill. We have something, and every legislative assembly does have something, I presume, like the Office of Legislative Revenue. And that office are the bean counters that determine how much a tax bill will be worth and how that tax money, that the revenue raised, will be portioned out and what kind of benefits will derive therefrom, right? So if a bill does not have a House bill on it because it's not a revenue bill, they don't look at it. They would have no basis to have it on their desk. So they never knew about Mr. Mumau's law. The only people that knew about it and heard testimony on it, besides me, and I bought all the original audio records of the hearings, and I was the first person after almost 30 years to hear what happened during those committee meetings. There was no member of the public there. There was no press there. It was only a very small joint committee of reps and senators. But I was the first person to hear this. And soon after Mr. Mumau's petition was read into the record saying, historically we've been doing this without authority in law and we'd like to continue to do it, but we need your permission, this one senator goes, well, how many vehicles are involved in this illegal titling scheme? And you hear a voice pipe up in the background. She obviously didn't have a microphone. She wasn't sitting at the table with the reps, but you hear a voice kind of squeaking, I'll go find out for you. And it just so happens that as a result of my diligent research, I find out that this is the committee administrator named Claudia Howells. So Claudia, the only recourse that she had to find the answer was to go to the Legislative Revenue Office, which of course didn't know anything about the bill because it was a Senate bill. And she never came back on the record with her answer. So it's not the Legislative Assembly per se that I have a bone to pick with generally, although I have a number of favorite bad guys in the Legislative Assembly, but not them generally. It's particularly the bureaucrats who have survived from one administration to the next, one group of legislators to the next. Typically legislative council. There is one old guy there, the oldest guy in our state legislature. His name is Peter Courtney, who's extremely, maybe I should say acutely aware of what's going on in this traveling scandal. He's still there. He was there in 1985, my first year as a legislative lobbyist in family law. And he and I haven't talked since I left the family law arena. When I realized that there were these larger issues going on, we never talked again. It's been, I mean, let's see, that year, the year that John Ellis said you have to provide equal protection and pass a law to take the license of doctors, architects, landscapers, and other professionals. That was 1993. And, oh no, that was 1995. The first one, the driver license, was 1993. I haven't talked to Peter Courtney, the president of the Senate, the oldest guy in our state legislature, since then. But these are the kinds of exciting adventures that are out there waiting, not only for me. I was in court this morning, the presiding court judge in Clackamas County, but for you. Any of you folks that are playing video games because you need something to do to fight boredom, think about the wonderful world of reality that is just knocking at your door. You have the corrupt judicial system, and you have the legislative assembly. You have attorney generals who know darn well. And let me give you an example of the attorney generals knowing darn well. At one point, I was being prosecuted for calling the legislative assembly. I had a period of time when I kind of designate as my investigative period, and I was still in my investigative period learning about the motor vehicle laws. And I was accused of calling the legislative assembly for the laws related to motor vehicles, and tried. And I said, I don't really want to cause the taxpayer any undue burden. How about I plead guilty in exchange for the law that says everybody has to act like a motor vehicle operator and title and register their vehicle? And the judge said, well, don't you think that's a little ridiculous? And I go, yes, I do. However, that's what I want, and I'll settle. And he goes, well, why don't you just settle for, why don't you just plead no contest to one count instead of calling 4 different staffers, and I'll help you get the law, and we can work something out on probation or something. No big deal. And I go, well, that sounds like it's going in the right direction. How are you going to find out? He said, I'll write to the Attorney General for you. Back to the Attorney General. And I said, that's great. There must be at least 250 attorneys over there. Which one are you going to talk to? And he said, your choice. I said, really? I'll take the chief deputy, the guy who survives from one administration to the next, one elected official to the next. And he says, oh yeah, Peter Shepard, he's a good man. Let's ask Peter. And I said, yeah, Peter's good. Let's. Just so happened that I'd already written to Peter and asked him for a public record about who has to have a driver license. And Peter had already told me that it's not the general public. So I had Peter over a barrel. He couldn't change horses in midstream. So now he's going to have to say, who is it that has to act like a motor vehicle operator and title and register their vehicles? So Peter finally, the judge said, you can even write the letter to Peter yourself to make sure you get what you want. I go, really? Shake on it. And we shook. And so I wrote to Peter, and the judge sent it, and Peter wrote back to the judge because it was from the judge, and it's addressed to the court case. And that case number, for all the researchers among us, it's Marion County Circuit Court case number 07 for the year 46583. 07C for criminal, 46583. And Peter Shepard's letter should have been item 130 on the case register, but somehow it got lost. The last thing right before that, where he sent the letter in, is the judge's request that I wrote for it, but his response didn't get entered in the register until a number of years later, when I'm arrested for calling the legislature again, and I'm on trial, and my friends are going down there and looking through these old records and realize, oh, it's not there. And at that point, my friends took a copy that had been faxed to me and took it down and filed it in that, under that case number. And this time they got a received stamp on it. So now it's in the file again, but it didn't get there in 2007 when it was supposed to. It was dated 2007, December 15th, but from the Attorney General's office. Another little story about the Attorney General's office is an Attorney General's opinion, which they are referenced by the date that they were issued. In the Attorney General's opinion of August 28, 1929, our Attorney General at the time, Isaac Van Winkle, wrote an opinion in response to the Department of Public Utilities. Public Utilities at that time was kind of like a precursor to ODOT today, in charge of fixing the roads and maintaining the public right-of-way. And they were scraping the bottom of the barrel looking for funds to the damage that the big rigs were doing, right? And they said, Mr. Attorney General, are vehicles for hire, are they motor vehicles that are subject to the law that we could extract these from? And Mr. Attorney General Van Winkle wrote his opinion of August 28, 1929, and he said, no, I agree with the Supreme Court of Washington, state of Washington, in a recent case, Hertz Drive It Yourself Stations, Inc., the precursor of our current Hertz, when they said that vehicles that don't go out with drivers for hire, in other words, somebody who is an actual driver, compensated professional, are not motor vehicles subject to the law. So no, you can't extract fees from them. That's another little story about attorney generals and what they know and their complicity in this. I hate to go on about attorney generals, but I think I owe it to my listener to share probably my most compelling political story. At one point, a senator, this kind of involves a number of high statewide offices, this story. I was seeking the law that says everybody has to have a driver license, or who exactly is it that has to have a driver license. And a gentleman who's on the Senate committee, Transportation Committee, a farmer from Yamhill County, who I have subsequently developed kind of a personal relationship with. But at the time, I was asking him, I said, could you get me the law, the original legislative language that makes it clear who it is that the legislature is going to regulate on the highway? And he said, sure, I got this new hotshot attorney on my staff, and I'll get him to give it to you. So the time went by, and after a month and a half or so, I'm told by his staff that they're not going to do it, and that I have to go to my own senator, a lady named Catherine Brown, in order to get this public record. Well, Catherine Brown, I said, she's not really my own senator. She's never been a friend of mine, and I don't think she's going to change now, but okay, I'll try it. I'll give it a try. So I knocked on her door, figuratively speaking, and said, hey, I got referred by Senator George's office to get this law from you. No response. I said, hey, do I need to make clarifications? What's my expectation? Can I help you? Phone calls and letters, phone calls and letters. Months go by. And then one day, out of the clear blue sky, I am served with a stalking order from Senator Brown's office. So I'm never supposed to have any contact with Senator Brown again. Never come within visual contact of Senator Brown. And not that I had had any visual contact with her for years. As a matter of fact, the last time I had anything to do with her had been in 1997 when she opposed my last family law reform bill. I had spent a lot of time on it. I had a unanimous decision from the Women's Legislative Caucus to support it, and she came along and said, whatever Richard wants, don't give it to him. And so my bill was yanked at the last minute. And I went to her and I said, I will have your head on a platter if you don't come up with a logical explanation for that. And how the heck do you, who didn't even attend that meeting to vote, get the power to sway a unanimous decision? And she said, we'll talk about it later. I said, no, we'll talk about it sooner or I'm going to have your head on a platter. That was 7 years prior to the issuance of the stalking order. Our stalking order just so happens to have a requirement that you have repeated contact, that's 2 or more contacts within the previous 2 years, right? But she said it was 7 years before that this other thing happened. Anyway, her attorney and I ended up during this series of set-overs, which turns out were all unlawful, but during this series of set-overs on her motion, her attorney and I came to an agreement. What do I really want? I just want the law I was referred to your client's office to get. She said, well, will you agree that you won't blow the whistle on this stalking order, which isn't legitimate? Because it's a felony. It's a felony to use court process to thwart people in their political goals. In my case, it was a political goal. I said, yeah, I don't really care. I don't run in the same circles as she does. She can have the stalking order, I won't contest. So the deal was, if I don't contest, if I let her have it by default, then I can have the law that I'm looking for. And I even gave her a copy of the law. We had dinner together. We met at the law library on occasion. I gave her the law that I was looking for, and I said, I just want it authenticated. I want to end this controversy. I want someone with the authority to say so, which is probably legislative counsel, to say, this is it. This is it, folks. There is no other. This is the end of the controversy. These are the people that are regulated. It's professional drivers, nobody else. So I took the default. I didn't show up on the day of the final hearing, and I was supposed to get the law within 10 days from legislative counsel, within 10 days of taking the default. She reneged. I didn't get the law. I ended up moving on. I had other fish to fry, so to speak. But as the years went by, that was 2004, as the years went by, I heard these rumblings, these murmurings of what a bad guy Richard is, because Senator Brown, who's now the Secretary of State of Oregon, has a stalking order against him. He's such a violent, mean guy that the Secretary of State is afraid of him. So I thought, oh boy, I've got to get rid of this bogus stalking order. And I put a petition in for vacation of a bogus order. I get an email from the Attorney General's office and said, hi, I'm going to be representing Senator Brown, or now Secretary of State Brown, to oppose your motion for vacation. and maybe we should get together before we go to court and talk about things. And I wrote back and I said, yes, I think that's an excellent idea. We should probably talk about things. Well, we ended up talking quite a bit for some hours. And she ended up, oh, how did she come to be on the case? The attorney that I made the deal with ended up suicided. Maybe it's not exactly to coin a term, but she ended up dead under mysterious circumstances. And Kate Brown, the Secretary of State, couldn't find another attorney in town to take her case. So she went to the Attorney General. This is back to the story about the Attorney General's involvement. The Attorney General sent the senior Assistant Deputy Attorney General to represent Kate Brown. The first paper, the first legal document that was filed by this senior assistant was a motion to quash the subpoena for the Secretary of State. But that motion to quash had 49 pages of files from the dead attorney's office behind the motion as exhibits, most of which were correspondence from me to Catherine Brown's office seeking the record, saying, can I help? Do you need an explanation? All these business letters, right? It was an exhibit. It was a package of information in my behalf. It was all to my side of the ledger, so to speak. We went to the court on a hearing to quash the subpoena so Brown wouldn't have to appear. And afterwards, the judge said she doesn't have to appear. And I go to the senior assistant, I go, who put you up to this? And she said, John did. And I go, John? Are you talking about John Kroger, the Attorney General, personally? And she said, yes, the Attorney General personally. And just incidentally, at the bottom of her first page of her motion, she cited the law that says this is illegal. She said the law is, for the researchers among us, the law is ORS 180.220. And it says the Attorney General's services are reserved for the state agencies and their directors in their official capacity. It's not for personal matters like stalking orders. And it further goes on to say that any state agency director or head cannot hire any other attorney when they have an official piece of business to litigate, which clearly had been the case with Catherine Brown. She had this other attorney at one time who ended up dead. But either way, the Attorney General couldn't have been on the case. So this senior assistant Deputy Attorney General fingered her boss in my behalf as a criminal, committing the crime of abuse of public funds, or public services, in this case, to foster simulated legal process, which is what a bogus stalking order is, in order to cover up racketeering, which is what ODOT does. So that's, I'm sorry to get so drawn out in my story about an attorney general, but John Kroger just left office, resigned from office before the end of his term last summer, and he's become the dean of Reed College here in Portland. I'm not done with John. Now that he is not enjoying the immunity of his office, I think I might take another run at him. But these are some of the kinds of things. The Attorney General is sticking out there, the Legislative Assembly, our courts, the executive branch with Mr. Mumau and his admission that historically we have been doing this without authority in law. Maybe I should wedge in one more story just to bring closure here. His authority in law that he didn't have was supposed to be implemented by administrative rules. The nuts and bolts of his optional titling law that came out of Senate Bill 124. Well, I compelled the ODOT folks to adopt the titling rule, optional titling rule, in 2005. They went through this bogus, clandestine, it's supposed to be public meetings, hearings. Nobody knew about it, but I have some friends in, and I want to say, folks, government is government, and government is good. Government is us. Government is for our peace, safety, and happiness, and there are people in government who are actually helpful. I could not do what I have done. I could not have learned what I know without friendlies in government. So my friendlies in government told me that this was going on, told me that this clandestine process was going on, and that I needed to show up. I was the only member of the public to show up for the vote of the highway commissioners on this rule, optional titling rule. I brought them archival documents from Mr. Mumau's bill folder explaining exactly how illegal it had been and what he was trying to do, and that it was an option for most people to title and register their vehicles if they wanted to. And I handed it to him. I said, I hope you have a chance to read the packages that I have sent, that I've provided you. Do you have any questions? And I'm being intimidated by this big guy from ODOT. He's about 6'5", 3 feet across the shoulders, probably 350 pounds, the director of ODOT, and his minion is leaning over the mic and saying, "Get off the mic, get off the mic." And I'm saying, "So before I go, are there any questions?" And they said, "No, we got it." So they adopted that rule they didn't open the packages before they voted, but they voted to adopt this optional titling rule that says most people, it says members of the general public may now choose to title their vehicles, and upon titling, their vehicles become subject to all of the provisions of the vehicle code. The thing that they did not do was they did not implement the registration part of Mr. Mumau's law, the part where you buy a license plate. So in 2009, I went back and wrote that rule myself with the help of my state representative, and I said, let's amend the optional titling by replacing it with this fully informed consent thing. The essence of the rule that I wrote was, when somebody goes to the DMV to buy the paperwork for their car, the DMV clerk has to say, "Well, do you know that it's really a right for most people to use the highway and you don't have to do this paperwork, it's optional?" And if the person says, "No, I didn't know that," well, then the guy says, "Well, I have to inform you that it's only for professionals. Our office is for professionals, but if you really want to donate to our program, we can accept your money if you sign here that you've been fully informed and you really want to give us your money. And then we'll give you a plate." So that rule was filed in August, on August 28th, for the researchers among us, of 2009. That's when all hell broke loose for me, and I have been in jail more than 350 days out of the last 2.5 years since then. A lot of it spent at the Oregon State Hospital prior to dismissing charges because they don't want me to get on the record. They're saying, you will never be able to aid and assist in your own defense, so we're going to dismiss these charges, meaning you don't get to talk on the record. But that's kind of brings us up to now. And I could let this 3-minute interview go if you want to direct it. A lot of people today are young enough that they don't remember the expression, the public right-of-way. But think about it for a minute, folks. Who the heck do you think has the right-of-way on the public right-of-way? We, as a society, we have had the right to use the public right-of-way for about 1,000 years. 1,000 years ago, it was declared to be a right under the King's Peace, English law. In America, we have the right to go to the seats of government and petition for redress. We have the right to, we have religious freedom. We can go to church on Saturday or Sunday, whichever. We can we have a right to pursue an education. We have a right to pursue, not to maybe catch, but we have a right to pursue happiness. What if our happiness consists of going to work and making a buck so we can take care of our family? These are fundamental, constitutionally described, not granted rights that are all effectuated by the right to travel. It's a difficult assignment to speak to the number of times I've been in jail for petitioning government for redress. And to be frank, I can't remember. I've been in so many times that I can't count them all unless I went back to the records. However, I can say that since I wrote the optional titling and registration rule of 2009, the proposed rule, that these being more recent, I can say that I have been prosecuted or arrested under warrant from Clackamas County, Marion County, and Multnomah County, and done over 350 days in jail since March of 2010. The right to petition government for redress is a fundamental pre-existing notion, a human right. Governments, I'd like to address that in terms of the Oregon Constitution. We in Oregon have a constitutional provision, Article 1, Section 1, which was kind of plagiarized from Indiana, I might add, and the language of the Florida Constitution is very similar, but I really like it. And I think to speak to the issue of the fundamental right to petition, Article 1, Section 1 of the Oregon Constitution cannot be topped. Do you mind? We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, that all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. There's your fundamental right to petition government for redress. I've at least had an exciting life, fighting corruption in public office, addressing the corporate agenda. It's a wonderful way to fight boredom. It's a wonderful way to become acquainted with people who share something, to become connected in a community. And I would urge all of you to become connected to your community and fight.